Who are you? And where are you going? What do you want?
Hello and welcome to Trust and Estates Weekly. I'm your host, Kevin Bemmel, and I'm here every Monday, well, almost every Monday at 10 a.m. Pacific time. You may have noted that today's show, the title of today's show sounds suspiciously similar to last week's, and that's because I was so sick last week I couldn't broadcast. So I rescheduled last week's topics to this week. You can probably still hear a little bit of the lingering illness in my voice, but it's good to be back. And I hope that you are not experiencing the same thing. It was bleak, I have to say, but I'm after a course of antibiotics, I'm mostly on the mend now, and hopefully we'll be able to enjoy the rest of pardon me. So there you go. See, hopefully I'll be able to enjoy the rest of the end of the year festivities without any more days off for being sick. So today I'm going to be talking about a topic that is I don't want to say it's dear to my heart. It's aggravating to my heart, perhaps, but it is near to my heart. One of the biggest estates that I handle has had this issue, still has the issue, and it is to a certain extent an ongoing source of difficulty, if not outright aggravation. And that is what happens when a business owner dies. So you may be tempted to think this only applies with a business that's in a sole proprietor form, meaning that legally there is no distinction between the business entity and the individual himself. However, that's not the case. So the business could be a corporate entity, could be an LLC, could be a partnership. The form of the business doesn't necessarily matter. When a business owner dies, and apart from having an estate plan, there is a succession plan for the business. There is not a separate succession plan for the business itself. It will be, at the very least, somewhat problematic. And the reason is because once the business owner dies, whether he's the owner because it's a sole proprietorship, or whether he's the sole or majority shareholder of the business in a corporation, or whether he's the majority member in an LLC, the decision-making authority may now be attenuated, meaning that the person who ultimately signs off on decisions is no longer there, or may be gone altogether, meaning the person who ran the business and made all the decisions is now deceased. And so that's going to have a profound impact on how the business operates. And this is the situation that I have. So one of the estates that I administrate, the decedent had a business, happens to be a property management business. You'll see it advertised a little bit later on in the show, in probably about 10, 12 minutes, as a matter of fact. The business is actually, it is a corporation, but the decedent was the sole shareholder of the corporation, number one. And number two, he left no succession plan. And so when I was asked by the heir of the estate to administrate the estate, I took on the de facto role of administrating this business as well. Now, it's an interesting sort of legal issue, I don't work for the business. I'm not employed by this corporation. My responsibility is to oversee its operations. And so, but in between the time when I was given, between when I was asked to take on this role and was given a temporary appointment, okay, there was a time gap. And in the meantime, there were clients. The business happened to be a property management company. So the business had clients, and the clients, wanted their their business taken care of, but there was nobody who had authority to do so. So the current employees of the business did not have the authority to run the business, even though they had the knowledge and experience to do so. They had no legal right to run that business, and and more particularly, they had no legal right to bind the business to do anything. And so this became problematic from a banking standpoint, regulatory standpoint, et cetera. So there was a gap between when I was appointed what's called a special administrator, which is a temporary appointment pending the appointment of the actual administrator. And the reason, to digress for just a minute, the reason that there was a special administrator appointment really was to deal with the business, because under a temporary appointment like that, it can typically be done much more quickly than an appointment as the administrator. And so there was less of a time gap. Now, having said that, excuse me, there were still things that, for example, banks were somewhat reluctant to do because I was the temporary administrator, not the administrator. And so it caused a whole range of problems. Oh, pardon me again. So I'm not going to go into the details of that particular case. Um, they're not necessarily for public consumption, but I use it as an example, and of a situation where one might think, oh well, it's a corporate entity, so it just goes on about its business. But it's a closely held corporation. It's not publicly traded, and so the individual who had the legal authority to act on behalf of the whole corporation was gone, and now someone needed to fill that role in order for the company to continue. Okay, so that, and interestingly enough, that's unfortunately a not uncommon situation. Okay, business owners, especially when the business is it's run by one individual. That doesn't mean that doesn't mean that there's only one person working there. It just means that there's only one person who has decision-making authority. So when that is the case, and that person has not set up a formal succession plan, and when I say a formal succession plan, what I mean is something in writing that that in the case of a corporation, there is a corporate resolution adopting it. Okay, something like that that formally allows the corporation to act under the succession plan. In the absence of that, the decedent could tell someone, okay, I want you to take over the business, but that means nothing in the eyes of the probate court. Okay, and that's because once the decedent is gone, there's no evidence, at least legally binding evidence, that such was the wishes of the decedent. And more to the point, for a corporation, which is a legal person, okay, in order for the corporation to act, typically, and I'm not giving legal advice here, I just know this as a matter of business. In order for the corporation to act, there has to be, corporate resolutions and that sort of thing. So so for those of you who are business owners or professionals who are advising clients who are business owners, okay, even if you're doing what you think is a simple estate plan, if there is not a business succession plan, either separately or as an adjunct to that estate plan, your job isn't done, okay? Because that business will likely get caught up in the probate, or in, I should say, in the administration, not necessarily probate, but in the administration of the decedent's estate, and has to be dealt uh, with some additional work. Okay, so even if the business is owned by a trust, okay, so presumably now the trustee has the authority to oversee the business in the absence of a succession plan. But number one, does that trustee have the knowledge to oversee that particular type of business? And if not, does the trust give the trustee the authority to appoint people or hire people in that business to keep the business going or to do whatever needs to be done? Number one. And number two, will banks and other entities accept the trustee's administration of the business, if you will, outside of, or in the absence of, I should say, a formal succession plan that has been adopted by corporate resolution, et cetera. Okay. So these are the kinds of issues that are initially raised, and they can cause a tremendous amount of chaos for the business, for its employees, for maybe there are some co-owners who don't own the majority of the business, for the customers and clients of the business, even for people who have a responsibility to regulate the business, or to, like in the case of a property management company, there are all kinds of intersections between the company and regulators, even though they're not directly regulating the business. They're, looking to regulate the properties managed by a property management company. Okay, so all of those become complications that have to be dealt with in order to keep that business going, at least in the interim. Okay, so one of the first decisions that an administrator, I'm going to call it a personal representative, because it could be a trustee, could be an executor, could be a court appointed administrator. So one of the first decisions, and perhaps probably the most important decision the personal representative needs to make vis-a-vis that company is, are they going to continue to operate the company? Are they going to take a pause and then sort of figure out what to do beyond there? Are they going to shut it down? Are they going to sell it? Okay, and there's a difference, right, between shutting it down and selling it. Shutting it down means it's just shut down, that's it. Selling it means that it's put on the market in an attempt to monetize the business as an asset. Okay, and those decisions will rest on a number of issues. One is the estate's liquidity. Can the estate afford to continue to operate the business? Maybe the business operates or has been operating at a loss, and it was in some kind of turnaround. And so, the executor, I'm sorry, the decedent was contemplating maybe selling some assets in order to fund the ongoing operations of the business while it went through turnaround. Okay, well, now that the decedent is gone, if that isn't part of an approved succession plan, it may be that the liquidity in the estate won't allow for such a decision on the part of the personal representative. For example, the personal representative may need to pay estate taxes and maybe needs all that liquidity and possibly more in order to pay the estate taxes. Okay, so he doesn't have the option of taking that money and using it to pay for operations to turn the business around. Okay, on the other hand, the business structure may be such that if it's a sole proprietorship, it may be, as a matter of law, that once the decedent died, the business died with him, because legally the business and the decedent are the same, and so now that business no longer exists. Okay, this is one of the reasons why, with even a simple business, this is something to talk to your lawyer and accountant about, but it may make sense to form some kind of entity, an LLC, corporation, etc. Okay, and it may also depend on court oversight. So the personal representative may have what seems like a perfectly viable plan to continue the operations of the business. That doesn't mean the court has to approve it. Okay, the court may look at the issues differently, and the court may look at the situation and say, wait, you want to spend 10% of the estate's assets in an effort to turn around this business, but I don't see that that's a viable plan, and so I'm not going to approve the expenditure of that 10% of assets. You're going to have to close the business down or liquidate it. You're going to have to sell it, right? So all of those can play into what happens with a business when a business owner dies. Okay, let's take a quick break. We'll be back for more. When life brings unexpected changes, managing inherited property shouldn't add to your stress. Magnum Properties specializes in probate and trust real estate management. We handle the complexities while you focus on what matters most. From property maintenance to tenant relations, from legal compliance to maximizing value, we're your trusted partner through every step. Magnum Properties, Inc., turning property challenges into peace of mind. Call us today at 213-264-4396 or visit magnumprops.com. So I'm talking about, I'm Kevin Bemmel, the host of Trust and Estates Weekly. I'm talking about what happens when a business owner dies and what's going to happen to the business. So as a client or customer of the business, okay, what's going to happen with you? Okay, and that's that's really what I want to focus on here. From the heirs standpoint, the fact that the estate owns a business isn't too much different than that the estate owns any other kind of asset. There may be some issues as to about who may take over running the business among the heirs, if that's a possibility, those kind of things. Talk about those another day. What I want to focus on here is what happens if you're a client or customer of the business, and now the business is essentially tied up in the administration of an estate. So first and foremost, generally speaking, existing contracts remain enforceable. Okay, so when someone dies, okay, their estate essentially takes their place from a legal standpoint. Okay, so if the business is a sole proprietorship, that any contract the business had is now a contract with the estate, as opposed to the individual who is now deceased. Now, if the business is a corporation or an LLC, that entity remains a distinct entity from the estate itself. However, whatever share of that entity was owned by the decedent is now owned by the estate. Okay, so let's say that the business was done as an LLC, and it had two members. The decedent owned 75%, and somebody else owned 25%. So now the estate owns 75% of the business, and the other person, presumably who's still alive, owns the other 20, still continues to own the other 25%. Okay, so as a legal entity, the business continues to operate as an LLC, but the owners of it changes. Now, while the contracts, generally speaking, continue, how they're carried out may change. Okay, so for example, goods that are paid for, but or services that are paid for, but have not been delivered, they may become claims against the estate. Okay, so let's say the business is a clothing business. Okay, and you as a customer bought, maybe it supplies uniforms for your company. Okay, and you bought $10,000 worth of uniforms. Okay, so that contract is still binding between your company and either the business owned, now that's now owned or partially owned by the estate, or to the estate directly. Okay, but will the estate make those uniforms and fulfill the contract? Will the estate return the money? Will the estate contract out the work in order to fulfill the contract? All of those are possibilities, and the personal representative could seek court approval to do any of those things depending on what is best for the estate. Okay, and this is the key issue here. Whereas the business itself was able to manage its self-interest against the interest of its clients and customers, the personal representative has a fiduciary duty to consider only the best interests of the estate. And so if that best interest comes at some disadvantage, we'll say, to a client or customer, the court may still approve that action on the part of the personal representative to the detriment of the client or customer. Okay, and so while it may have been a good deal that you got in terms of cost of uniforms from this company, and it may be because of that, the personal representative goes to the probate court and says, Your Honor, I want to return the money from this contract because fulfilling the contract would cost the estate more money than it received from the client. Okay, and the court may very well say, look at the analysis and say, I agree with you, personal representative, and the court hereby orders that the money is returned and the contract is deemed fulfilled, or is deemed canceled, or however the court would look at that. Okay, so this becomes one of the big issues in terms of dealing with a business that either the business itself is now owned by an estate, or the estate is part of the ownership of the business. Okay, so and I'm not talking just about orders, by the way. Warranties, subscriptions, service agreements, they can be honored, they might be modified, they might be terminated depending on the estate's resources and depending on what is best for the estate. Okay, so as a client or customer, then how do you protect yourself? Well, first of all, you need to gather all contracts, receipts, invoices, emails, proof of payments to document any claim you have against the company. Okay. And indeed, you may need to file a formal creditor's claim in order to sustain your position vis-a-vis this company, especially if the company itself is now subject to probate, as opposed to, for example, being under the administration of a trustee. Okay. And I did a whole show on creditors' claims just sometime within the last few weeks. So I invite you to go check that show out to see how a creditor's claim works, at least here in California. But there are deadlines, and there are forms that need to be filled out. Typically, there has to be documentation provided that provides evidence of the claim. Okay, so all of that needs to be pulled together in order to protect your position. Okay, and just like the personal representative is going to be examining whether it makes sense for the company to continue operating, you too may need to, examine and make a decision as to whether continuing your relationship with this company makes sense, or does it expose you to too much risk, especially if there's prepaid services or long-term services that you're expecting from the company, and you're not sure the company is going to survive the administration, concurrent with, or not concurrent, as a result of the decedent passing. So all of that may cause you to say, hey, you know what? I think I'm going to terminate this relationship. Okay. And that may be the smart thing to do. By the way, just because assuming that you have the authority to terminate the relationship, meaning you're not contractually obligated to continue it, that all by itself wouldn't necessarily prevent you from nonetheless filing a creditor's claim. These are all somewhat complex legal issues, and I would encourage you to get proper legal advice, especially legal advice from an attorney who knows probate, if probate is the issue, or at least knows trust in probate law. Okay. Typical business attorneys do not necessarily have the knowledge and experience to deal with this kind of situation. It's a specialized area of the law, one in which you're going to want to make sure that you are properly advised. Okay, so your regular lawyer may be great at advising businesses, but it may be that you need to get a specialist in addition to get this figured out, and to make sure that your rights are protected, your legal rights are protected. Okay, so that's protecting yourself financially. Okay, protecting yourself more broadly typically will be a matter of proper communication. Okay, now I know for myself, when I am administrating an estate, and especially when there is a business as part of it, I tell the employees of the business, from here on out, all communication needs to be made in writing. Typically, that means by email. Okay, not by conventional letter. Okay, now that doesn't mean they're never going to speak to anybody. What it does mean is, if they do speak to somebody after that discussion is done, they're going to follow it up with an email confirming the conversation. Okay, and what that does is it creates a written record of what was said. Okay. Now, again, I'm not advising you legally, but from a business standpoint, if I send an email to someone saying, this is what we talked about, and they don't respond back, no, you're incorrect, I know I've got the stronger hand in terms of being able to, not determine, but being able to present what happened. Because if what I say in my email is inaccurate, my response is, well, if it was inaccurate, why didn't you say so at the time? Why are you saying so now? Right? That's just a kind of a common sense business issue. Okay. As well, so I think for the rest of the show, you got to count on periodic going dead sounds because I'm muting it so I'm not coughing in your ear. As well, I tell the employees, especially at the outset, that whatever decisions need to be made, especially anything that's not in the absolute routine course of business, they need to run by me. Okay. And that's because I'm the one who's ultimately responsible to the court. Okay. Now, over time, as I get to know the business, how it operates, I get to know the people, how they handle matters. I may modify that because I'll know more about it, and I'll have developed some trust with the people who work at the business, etc. But especially in the very beginning, I need to be careful that an employee is not inadvertently binding the business or appearing to bind the business to something that cannot be delivered to a client or customer. Okay. So I'm going to err on the side of caution at the beginning, and then kind of see how things develop thereafter. And that's one of the reasons why I limit communication to written channels. It's so that I have a record for the court, and so if I make a decision and later there's a dispute arising, I can go to the court and say, hey, here's the written record. This is why the decision was made, etc. Okay. So as the client or customer of a business that's, again, either going through probate or is owned by an estate going through probate, or for that matter, a trust that's being administrated, it's most likely going to slow down response times as the business navigates both the operational issues of having this new person essentially in charge, and dealing with uh, not so much legal compliance per se, but dealing with the added layer that comes from having to make sure that decisions can be documented in court if necessary. Okay, let's take another break. Probate and Trust TV, your curated source for the most useful and insightful content on estate planning and trust and probate administration, featuring standout professionals like Bill Gross, Paul Brabelet, James Cunningham, and yours truly. Whether you're a lawyer, accountant, real estate professional, or working on your own succession plan, this channel helps you quickly find the clearest, most practical content YouTube has to offer. Subscribe now to Probate and Trust TV. Spend more time learning, less time searching. So we're talking about when a business owner dies and what you or what people who are customers and clients of that business need to know in order to, as successfully as possible, navigate dealings with this business that either now itself is going through probate, or its owner, or more likely majority owner, his estate is going through probate or is being administrated as part of the assets in a trust. Okay, so what can you expect from the personal representative? That is the the executor, the court-appointed administrator, or the trustee of a trust, right? All of those are forms of personal representatives. So again, I want to emphasize this. Their legal duty is to the estate or to the trust. It is not directly to the clients or to the business itself per se. The business is an asset of that trust or an asset of that estate. Okay. And as such, it needs the personal representative is going to look at it as in the context of all the other assets and what makes sense for the estate as a whole. And in the case where it's a probate, how the court might interpret what is best for that estate. Okay. So in a way, there might be some second guessing going on. So what I may think makes the most sense as a businessman. Okay. So in other words, if I were literally the decedent and instead of him dying and me being the administrator or the personal representative of his estate, I'm literally going to stand in his shoes. Okay. What decisions I would make might be different than the decisions I might make as the personal representative who has a fiduciary responsibility to administrate that estate for the benefit of the estate and essentially through that for the benefit of the heirs of the estate. Okay. Those are very, very different. So let's say, for example, that the decedent's heirs are all children. They're all minors. Okay. And let's say further, for whatever reason, he's not married. Maybe he's divorced. Maybe he's a widower. Okay. Or in the case of a woman, she was a widow and then she died herself. Okay. So is it in the best interest of those minor children for the business to keep operating? Okay. When they're too young to legally have any authority over the operation of the business directly, even after a probate closes or even after a trust is settled. Okay. Meaning there's always going to be someone who's going to have to oversee matters on their behalf until they become adults. Is that a good situation for these in which in which these heirs to be? Okay. And there's no set answer to that. The answer is it depends on a whole range of factors. Now, by the way, maybe a couple of the heirs are teenagers, okay, 16, 17 years old, and maybe they've actually been working in the business part-time for several years, and the hope or expectation was that when they were old enough, they were going to take over the business, and they're very desirous of doing that. That's a very different situation from one where the minor children are literally children, 5, 6, 8, 10 years old. They have no connection to the business. And it's going to be, a decade or more before they're old enough to legally be able to act on behalf of the business, assuming that it's, out of probate or the trust has been settled. So those are the kinds of issues that are going to need to be wrestled with that impact you as a customer or client, or impacts the people who do business with this company. Okay. Now, having said that, it generally makes sense for the personal representative to sort of manage or administrate the situation in a way that the estate cooperates with what's happening with the company and its clients and customers while all this gets worked out. Okay, so it wouldn't do to, purposely antagonize them. Now, having said that, I've had situations where the clients were antagonistic from day one because they were mad that the decedent died and left no succession plan, and now maybe their money is tied up, or whatever is going on that they don't like. Okay, so what I would say is, as the client or customer of a company that is going through the administration of an estate, it doesn't do you any good either to be hostile to the personal representative. Okay, in most cases, there's nothing he can do. Okay, first of all, if he hasn't officially been appointed yet, there is nothing he can do. Okay, so you can call up and complain to him all you want, and the response you're almost for sure going to get is, I hear your concerns. There's nothing I can do until the court formally appoints me. That's just the reality of an estate going through a probate. Now, by the way, if this is a trust, in theory, things should go more smoothly in the sense that the successor trustee takes over. But that doesn't necessarily mean that will be the case. So to the extent that there is, shall we say, bad blood between the successor trustee and the beneficiaries under the trust, okay, there could be legal action taken to try and prevent that trustee from acting. Okay, and so if there's a challenge to the trustee's actions, okay, a peremptory challenge in essence. So while it would seem like the trustee stepping into that role now has the power to act, the trustee may be reluctant to act while the issue of his authority is before the court. Okay, minimally, it's going to slow things down because he's going to be more careful about how things are done, how they're documented, etc., so that he doesn't find himself in, a very problematic situation when he has to, or if he has to, defend his actions as a trustee in court. Okay, now here's the other thing. You may have been very close friends with the decedent and had kind of a preferred client relationship with the business. Such a situation has no bearing in a situation where the business, where the operation of the business is now being overseen by the probate court. Okay, that kind of preferential treatment could potentially get the personal representative into trouble if he continues it. Okay, especially if it's prejudicial to the best interests of the estate and eventually to the heirs. So I have a situation, or I had a situation where the estate was co-owner of a property with another individual. And this individual claimed to be a very, very, very close friend of the decedent. And therefore, he wanted certain things done because of that close friendship. Okay. Now, what he wanted done was not in the best interest of the estate. And so I refused to do it. But it caused a lot of bad feeling on his part because he felt, because he was such a close friend of the decedent, I should have done what he asked. So I will tell you, this is kind of my rule. the more often somebody claims to be a close friend of a decedent, and the closer they claim that friendship was, the more skeptical I am. Okay, because in my experience, that's typically being said in order to try and get some kind of advantageous situation, getting me to agree to some kind of advantageous situation on the part of the person who's claiming to be such a close friend. Okay, so if you were genuinely a close friend of the decedent, it's perfectly fine to say so. But I would advise you, again, from a business standpoint, you may be doing yourself a disservice if you try and trade on the closeness of that friendship. Okay, I'm pretty sure that my experience with so-called close friends of the decedent is not unique. Okay, so the court is not going to allow preferential treatment, and the trustee of a trust should not allow preferential treatment of clients and customers, especially if it's to the detriment of the beneficiaries of that trust. Okay, so keep that part of the situation kind of separate from the business dealings, from the dealings with the estate. Again, it's I'm not saying you shouldn't tell the personal representative you were, a good friend of the decedent, but leave it at that. Don't try and make it part of the negotiations or arrangements on the business side of things. By the way, I will say, in contrast, the people who I find were probably genuinely close friends of a decedent are the ones who typically say to me, I was a good friend of such and such. I Unfortunately, this looks, from what you're telling me, this is going to be a mess. Hey, just please let me know how I can help. And in the meantime, we'll work this through as best we can. Now, by the way, that's how you would hope that a close friend of a decedent would act, right? And so, if indeed you are a close friend of someone who's passed away, leaving behind a business, and you have dealings with that business, so I would encourage you to act the way you would have to your close friend, i.e., how can I help you? Okay, he's gone, but gosh, if he was such a close friend, hopefully you want what's best for his heirs, his spouse, his wife, his children, or whoever, right? So it's just some food for thought for you, as you think about this. Okay, so finally, when does it make sense for you as a client or customer to move on? So, first of all, if it's a probate and the estate is insolvent or struggling, and clients may only receive partial payment on claims, or maybe nothing at all, at that point, it may make sense to move on. Spending money on attorney's fees to try and get water from a well that's run dry, may not make any sense from a business standpoint. Okay, and don't be hesitant to have those kind of candid discussions with the personal representative. It's perfectly reasonable to say, what do you think are the chances that I'm going to get paid, right? And look, I've had those conversations, and I let them know, look, this isn't this. It's if it's a claim, that's reasonable, and I think it should be paid, and there's liquidity to pay it, I'll say so. On the other hand, if it's a claim that I don't think should be paid, I'm going to reject the claim. Okay, and why did you reject it? Well, the fact of the matter is, there's no money to pay it. So the estate is insolvent. So you can go ahead and file an appeal, but you can't get blood from a stone, as they say, or something like that. So, you know, at least ask the questions, but you know, don't throw good money after bad. Okay, if you're confident that you do have the facts of the situation, review what actions you may want to take in that light. Okay, and consider the disruption, the unpredictability. How is this going to impact your own how is the unpredictability and the and potential disruption to your operations and your plans, how is that going to affect your business, or your maybe your ability to live your life? Okay, it may not make sense for you to continue, and you may just sadly but have to decide, look, I need to move on. I can't continue to operate my business in this atmosphere of uncertainty. Okay. And so the practical decision may be for you to find a new provider, rather than wait for the probate to get resolved. That just, you know, you are not, there is no moral obligation. I put on my rabbi hat now for a moment, right? There's no moral obligation for you to continue doing business with a company that's going through probate, or if it's owned by a trust where there's issues of who is going to have the authority as trustee, etc. You're not bound to sit through those to your own detriment. And so in the end, while you may have legal redress, the cost may be too high. The cost, not just the financial cost, the cost of uncertainty, etc., to your business. So these are the kinds of issues I would encourage you to consider if you end up as the customer or client of a company that's going through the administration of an estate, or that's connected to the administration of an estate. Okay. For the legal and accounting issues, again, reach out to your lawyer, your accountant. If they don't have experience and knowledge specifically in dealing with probates and trusts, make sure you get that specialized knowledge in addition to theirs. Okay. So I thank you very much for joining me on my first show back after a week of being sick. I hope that the muting of my microphone didn't make it too difficult to follow. And excuse me, I am back to I hope to a full slate of shows this week. So tomorrow at 10 a.m., tomorrow, Tuesday at 10 a.m. Pacific time, is my show, Business Lessons from the Military. Wednesday at 10 a.m. Pacific time is my show, People Making Money. And I think, if I remember correctly, let's see. Yes. And on Thursday is at 5 p.m. Pacific time is my show, Jiggers' Place. Whereas the week comes to an end, we'll sit back and have a cocktail and a schmooze. So I thank you very much for joining me. If you have any questions, comments, thoughts, feel free to post them in social media. All the links will be in the show notes. If it's something personal, you can email me. My email address is there as well. If it's something within my area of expertise, I will be happy to respond. And if it's something that you need to seek legal or accounting advice on, I will let you know. And if you need help finding a good lawyer or accountant, I'll be happy to help you with that as well, or financial advisor. So again, thank you so much for joining me today. Wishing you a wonderful rest of the day, and signing off as I always do. Marie, darling, you are my belle. Courage at all times.